We're going to ask what role can restorative justice have, and can it align with Indigenous culture? And this whole conversation, I think, around justice and Indigenous culture is a really interesting one. And I keep on coming back, as I've been thinking about this, to the wonderful welcome to country that we had from Rodney Carter last night, where he spoke about being, an Indigenous man, and then speaking to the family court about his culture and the importance of that being understood, that knowledge and that law and those connections being understood by the imported Anglo culture, Anglo legal culture and law that we have here. And I think that was a really wonderful illustration of the fact that we need to be awake and alive to what's all around us. Our speakers this afternoon, David Moore, lawyer Nick Espie and Auntie Lois Peeler, will talk us through restorative justice programs that they have intimate knowledge of, and they're going to help us explore the potential benefits of restorative justice models within Indigenous communities. So how does restorative justice work in Indigenous communities? Can it improve community safety and lower incarceration rates? How can we distinguish success from failure? How do the principles of restorative justice align with traditional values and practices? Can restorative justice programs forge a link between traditional Indigenous values and our criminal justice system? Our first speaker is Nick Espie. He's an Arrernte man with family ties to Alice Springs. He also has family connections to the top end, and through his kids, further family connections in the Kimberley. Nick worked as a lawyer in the NT before moving 11 years ago to the Kimberley region. He spent 7 years with the Aboriginal Legal Service of WA and 4 years with Legal Aid Western Australia. Now, Nick is currently, and this comes back to what we were talking about this morning, he's currently working for the NT Royal Commission into Juvenile Detention and Child Protection as a community engagement officer, and he will return after working on that project. He will return to WA Legal Aid when that's done. Would you please welcome Nick Espie?
Good afternoon. I'd firstly would seek to acknowledge the traditional owners whose land we're meeting on here today, and thank you all for being here and for the invitation to speak. As mentioned, I'm a lawyer that's worked in the Northern Territory as well as the Kimberleys. Speaking about the issue of restorative justice, I guess firstly, I suppose I would acknowledge that restorative justice itself is somewhat of an Aboriginal concept and process. It is the process of which disputes have been settled by Aboriginal people in this land, and certainly from research it seems Indigenous peoples in other parts of the world also have similar processes. Having said that, it does seem people in the Northern Territory and elsewhere have looked towards places like Canada and New Zealand for inspiration in finding restorative justice type programs and solutions. However, I also would suggest that there are many local solutions, many local programs that are already working, already integrating traditional customs with the Australian legal system, both in the courts and outside of the courts. There are a number of law and justice committees running in the Northern Territory. These are groups consisting of a panel of community elders, representative of various family groups or clan groups within those communities. There's the Kurtji group in Lajamanu, who've been operating for many years and are perhaps one of the earliest examples of these types of committees. The Bunawara, who are a group in the community of Maningrida in Arnhem Land. There's also another group, the Ponki mediators, who operate in the Tiwi Islands. These groups have involvement in the court process. These days that's usually in the form of meeting prior to an offender going to court, producing or after discussing the various offences that a person may have committed, discussing it with each other, they being fully informed of those offences and the circumstances, they produce character reference type letters, or letters that are delivered to magistrates and on occasions judges, discussing the offender, the circumstances, cultural matters or personal matters relevant to the offender and to, in cases, victims. This is an example of where these people often consist of the lawmen and lawwomen of those communities, senior law people within their own legal system, and having met a lot of these elders, I can say they're people that can speak with great passion about trying to find common ground where the Aboriginal systems and the non-Aboriginal legal systems can work together for the benefit of their people. Similarly, in Turkey Creek or Warman, which is a community in the Kimberleys, the East Kimberleys, for many years there's been a group of elders that would sit on the bench with the magistrates while court presides. They would offer advice, insight and comments to the magistrate. They would also, on occasions, address the offenders, who are often people they know, often, well, always a connection of some sorts to those people that appear before the court. That creating a system where that court process is more a system of being judged by your peers and by your elders in the community, and perhaps a way of making people more accountable. The Ponki mediators are also, as I said, a group in the Tiwi Islands. They often not only provide references for the benefit of the court, but also solutions, including culturally appropriate rehabilitation options, culturally appropriate peer support. That's often in the way of finding the appropriate person with the appropriate kinship or skin name relationship to that person, being the one to assist them, facilitate rehabilitation within the community. These are all things that are going on now, have been going on for a number of years and having some degree of success. As I said, the Kurtji group is one group that has been around for some time. Just going back a number of years now, back to 2002. Firstly, whilst acknowledging there are many traditional ways of dealing with conflict and disputes and dealing with people who've broken Aboriginal law, many of those options include mediation, where families talk and discuss offences. There's occasions where people are banned from their community or sent out to various parts of their own country as options. Having said that, corporal punishment is also something that is part of Aboriginal tradition. It is a way that disputes have been settled. It's a way that has in fact been known to the court and been addressed in the courts in the Northern Territory, also in Western Australia and other parts of the country. And I say, going back to 2002, I make mention of a matter. There was an offender by the name of Kevin Webb who stabbed a number of people in Alice Springs, including killing one person. This matter sticks in my mind because I happened to be driving past the scene where the victim lay dying on a crossing within the township. Kevin Webb was a man that was given bail prior to his sentencing. He ultimately was sentenced for manslaughter. But back in 2002, he was granted bail to return to the community of Newrapie. Magistrate who granted bail was aware that the purpose was to go and receive traditional punishment in the form of payback. Specifically, or ultimately, he was speared 13 times in his leg by members of his family and the victim's family. Certainly, this is people nowadays would consider quite harsh punishment. It's something that is at odds with the Australian legal system. This caused some discussion. In fact, 2 years later, there was a similar situation where a man named Jeremy Anthony applied for bail. Mr. Anthony had killed his wife. He was responsible for her death. He's someone that had, not taking into account obviously the seriousness of such an offence, he'd shown quite genuine remorse and shown a desire to be subject to payback in his community of Larjamanu. On this occasion, as I said, there had been some discussion prior to that and some debate within the legal circles about this. Magistrate on this occasion didn't grant bail with those conditions. The bail essentially was that he could go and reside at the community of Nooka rather than returning to Larjamanu, where he was likely to be subject to this payback. And the main reason being the legal system, within the legal system, whilst we can consent to assault, a person can't consent to injuries that would, under the legal definition of grievous bodily harm, occur to that person. Mr. Anthony was granted bail, told not to go to Larjamanu. However, he did travel to Larjamanu, and he also received payback. He received that traditional punishment, which included being speared in the leg by his deceased wife's family, and also being struck by members of his own family. Whilst these things are quite harsh or considered harsh, they're organised affairs. On this occasion, the judge that subsequently dealt with his sentencing took into account that he'd received this punishment. There was affidavits produced to the court by elders in the community who sat on the Law and Justice group. They discussed what had taken place in detail. It wasn't a situation of a lynch mob attacking the person and dishing out punishment. It was all organised affair. It was seen within that community as a restorative process, as almost a reconciliatory process, and that was a matter that occurred in 2004. Certainly there's not so much discussion on that sort of form of customary intervention. In 2007, the Northern Territory had the intervention, and it became... The Northern Territory National Emergency Response legislation was enacted. Section 91 of that legislation specifically prohibits courts taking into account customary law in matters involving either bail or sentencing of offenders. It is unfortunate that those types of matters are the only ones that were focused on in a negative way. As I said, elders and community groups have many ways of dealing with offenders. Notwithstanding 10 years of specific prohibition on taking that into account, these groups have prevailed. Innovative options do take place in communities. Whilst there are these options that include things that occur in court, there's also solutions that can happen and do happen outside of the actual court process. There There are people with innovation and with the right attitude working either for Aboriginal communities or working with Aboriginal people. As I said, there are people quite passionate, Aboriginal people that are passionate about bridging that gap. One thing that's relevant to restorative justice, and restorative justice in the sense that it's a process where affected stakeholders play a part in solutions to offences. And looking at the bigger picture, there are programs running in various places. One thing I'd also mention is night patrol or warden schemes, which are part of many communities. Started way back, or many years ago, about 40 years ago. It was one of the first programs that was run by a bunch of elderly women that were concerned about children, concerned about families, and upon their own initiative set out to patrol their communities and deal with disputes, mediate disputes. And this is something that's thrived nowadays on occasions. The community of Balgo, which is in the Tanami Desert at the edge of the Kimberley region, is a community where when I first started working in the Kimberleys as a lawyer, there was an officer in charge of the police station there, a two-man police station. The sergeant who worked there was also an Aboriginal man from the Kimberleys. He's someone that showed the respect to the community. He's someone that consulted with the community, and that was reciprocated. The people within the community respected his judgment. He was well aware of the community-type meetings that occurred within the community. Often meetings are held in a public space involving people on either sides of some sort of dispute. He was someone that would allow these meetings to take place. Occasionally they were perhaps situations that got loud and heated when there was debate about various issues. However, he was someone willing to stand back and allow this process to take place. On top of that, he was someone that formed a warden scheme consisting of leaders within the community and essentially empowered local people to find solutions, to settle disputes, to reduce offending against each other and also offending by way of burglaries or property damage within the community. Unfortunately, he ultimately left that community and went on to other things. And I guess it raises the issue that there can be these informal things that take place that have great success, don't necessarily involve reinventing the wheel, so to speak. Unfortunately, sometimes all it takes is one person to leave and someone else to replace that person. That community subsequently had a new officer in charge that didn't have the same respect to the community, showed somewhat of a zero tolerance to community meetings, which may have got a little bit loud. In fact, I can recall attending the community as we would do on the court circuits once a month and finding people charged with various offences relating to disorderly behaviour type offences, simply for being loud, yelling or perhaps swearing. So that was a community that had struggled to be able to resolve their differences based on the traditional way of meeting and discussing problems. I recall, and I guess going back to the fact that there are still some strong connections to culture, to traditional customs. There was an old man whose name I won't mention, a matter that was dealt with before Magistrates Court, who was charged with striking the woman that was in, he called his wife, a younger woman that was in that, through this kinship system was considered his wife by their skin names. There was a dispute involving her. Traditional custom dictated that it was his role to punish this woman. This was an old man that was born in the bush, grew up a traditional life, had never seen a non-Indigenous person until he was a young man, as is the case with many people in the desert region. Speaking to this man and asking him what happened and what the story was, it was quite evident that it was a situation where he felt that striking this woman was the best option to reduce conflict within the community, to reduce the situation where other people would step in and would commit violence against her as a form of payback. He was also someone that believed in tradition, in spirituality, which may also be considered to some extent the superstitions of Indigenous people. And it was his belief that should he not deal with this matter, harm would come to this woman in a spiritual form. So those are some of the dilemmas and the tricky situations that are faced by police and faced by the courts. In any event, that community, as I said, there was a zero-tolerant approach. Not that I'm condoning that sort of violence, but that's a community that's now spent a number of years dealing with feuding, which spills out into the streets of the community in the way of family feuds and often violence. Dealing with Aboriginal people, there are some programs that succeed, some that fail. Using that community again as an example, the legal aid service in Western Australia, in fact the office I've left for a short period of time, had as a community engagement officer that attended that community, an Aboriginal man that worked in that community, and discussed and facilitated the possibility of assisting in mediation. And I spoke to him just 2 days ago and to ask how that process was going, and he told me essentially that they'd stepped back whilst they'd offered their services to assist in the community. Simply having that conversation was enough that it kick-started people in that community to resolve the matters themselves, and they have since, as I understand, mediation's taken place and conflict has relieved itself. This is a community that has, in the last few years, because of various feuding and disputes, there has been somewhat the overhanging threat of community closures, and specifically the threat that if the community didn't resolve itself, there would be closed. Also, similarly, it was a community that was government had strong desires to also subject people in that community to welfare management, which is being trialled elsewhere in the Kimberleys and also South Australia. There are other initiatives that I would touch on that again are not necessarily court-based initiatives. Another community in the Kimberleys of Ulumbarra was also a community where there was a lot of conflict, a lot of feuding, which was often in the form of hundreds of people throwing rocks, sticks, burning each other's property. There was a change in staff at the police station, and there was a sergeant that subsequently ran the police station. He believed in community policing. He consulted and got to know the community quite well, and ultimately was right on top of any conflict that arose, to the point where he would invite anyone that had any sort of disputes to the police station, not in a situation to charge them. He would sit down with them, talk about their problems, and at the end of the day, he'd take a photo of two young men, for example, with their arms around each other or shaking hands. He'd give them a copy of that, and it would be left at that, as opposed to their individual disputes spilling out into the community. He's also someone that Another simple idea he had was when people would come into his police station yelling, shouting and swearing, rather than, as was the case with previous police officers there, charging them for matters involving abusing them or disorderly type matters. He had a barrel of lollipops and would give a chup-a-chup. And he says the most angry and aggressive people would soon be quiet and have a lollipop in their mouth. He's someone, again, that gained the respect of the community, assisted people in mediating, in having common ground and being able to resolve their differences without violence. Another situation, another community in Northern Territory, the community of Wadeye, which was over the years known for similar type violence in the form of two large gangs that often opposed each other and caused chaos in the community. There was the coming together of these two groups, initiated by one of the officers that worked in the community. He recognised these two gangs were really extensions or modern versions of the traditional clans and systems. It got to a point in that community where, again, he empowered these gang leaders who shook hands and then began running a night patrol program, which brought peace to the community. And this is a community that a few years prior had riots that had involved an officer actually shooting and killing a member of the community. Peace had been brought by this simple act of speaking to the community, asking the questions and understanding the dynamics. Having returned to that community after the school holiday period, had a positive conversation with the principal of the school, who advised that it was the first time in years that the school hadn't been broken into. So not only had the community had peace and conflict had been resolved, but other offences, property damage and the like, had reduced, because it was a case where the younger people in the community who would commit those sort of burglary or property damage offences respected the people that were patrolling the streets, so to speak. So those, as I said, are things that occur outside of the court, as well as some of the programs such as the law and justice groups that occur within the court system. And I suppose, how do we forge those links? It's reciprocating the respect of the systems. Perhaps not to finish on a sad note, but I mentioned the elders in the Warman community who sat for many years, probably more than 10 years, with various magistrates. Unfortunately, as I said, it often takes either the right or wrong attitude to make something a success or a failure. Quite sadly, I was approached by the elders at the first sitting of a court in Warman with the new magistrate a number of years ago, who they wished to meet with prior to the commencement of court. They were there quite early, waiting to speak to her, introduce themselves, offer their service again. And quite unfortunately, the middle of the morning when the court had then commenced, and she hadn't sought to talk with them and meet with them, they sadly left. And that's a program that has now ceased. And it's, I suppose, perhaps a sad example of those people being passionate about what they would do, being able to provide that for their community at no cost. It wasn't something they volunteered their time, and unfortunately that fell over. I'm not sure how I'm going for time.
I think we need to...
About time to wrap it up.
We've plenty of time during the panel.
Yeah. Perhaps I'll leave it at that, and maybe other questions.
Yeah, great.